Thank you first and foremost for having me. I'm excited to be on with you guys. I hope everybody out there in virtual land is safe and sound and their loved ones are not sick and feeling good. And thank goodness for the sun, as Walt likes to say. I think it's a lifter for today. So I wanted to start this presentation by just stating that, there's a lot of things out there right now. There's a lot of information as to what is and what is capable. A lot of things are being touted by attorneys' offices and title agents as to what they can and can't do. And this is just a portion of what is coming and is possible under the new things that are happening every day as they unfold before us in this virtual world that we have created in the last 4 weeks. I think it's pretty impressive. I just want to start by saying that, in the settlement world, it takes a lot of people coordinating to get these things to closing. And so it's pretty incredible that in the matter of 3-4 weeks, we've gotten to this point where we are now with these virtual situations and what is possible given that such a short time frame. Necessity drives need at times, and the demand and things like that. So there's a lot of changes, and I'm going to speak to the difference between e-closing and virtual settlements. I'm going to speak to the remote online notarization process and how that's proceeding before us. And when I speak at first, I'm going to speak in generalities as far as it goes to Delaware and Maryland. Obviously, I'm licensed to do as an attorney in both states. And obviously what I speak to initially will be applicable to both states. When there is a distinction to be made, I will make it. And there are distinctions, especially when we get into the RON. I'm going to refer to that as RON throughout the portion of the proceedings. That's a remote online notarization. Okay, so there's a lot of things that have to go on for us to get there, but that really has to do with notarized documents and how we can remotely get documents notarized using virtual technological tools. So first to start here, let me get to my outline. First of all, I want to say that for purposes of virtual notary, e-closing, RON, everything that we're going to talk about, nothing's changed in terms of nobody has to close this way. Nobody's holding anybody's feet to the fire with regards to the old way of doing things that I'll refer to as sitting in a conference room and getting things done. Obviously, these are tools that we have come up with in the industry to help alleviate and to adhere to the guidelines and to the restrictions and to the modifications to those emergency orders that the governors and the president has put in place with regards to social distancing and how close we can get to each other and how much interaction we can have with each other and how many people can be in a room and all of those things. These e-closings and RON and virtual settlements are not mandatory. Nobody has to use these, okay? And there's a lot of different ways that attorneys' offices and title agents in Maryland are getting things done. From, I've heard drive-through settlements where the people are driving up and things are, the documents are being passed through the window. The attorney then goes inside and calls them on a FaceTime, to video conferencing with a notary in site, on premises rather, so that they can notarize those documents. So there's a lot of different ways that this can go. But what I'm going to speak to first is the difference between e-closing versus a remote online notarization. So you hear a lot of times about, oh, we can e-close, and that's that's a lender terminology, right? A lot of lenders are going to go, we have the ability to e-close and e-sign documents, meaning you can upload the documents onto a platform, and then the signer goes on, whether it's a buyer or seller, whoever it is, and e-signs those documents if it's capable. Obviously, if you're doing an e-closing as a title agent or as an attorney's office, there's a lot of things that have to happen. First and foremost is if it's a lender package, the lender, as well as all the parties, have to accept that the parties are e-signing, meaning you have to, as an attorney's office or as a title agent, make sure that you're getting everybody's permission who's party to the agreement, that they're allowed to go ahead and e-sign these documents before we go ahead and get started. A lot with the e-closing though is how do we differentiate which documents can be e-signed versus which documents need to be quote unquote wet signed, meaning they need to be signed in person and actually have a signature and not be an electronic version of those signatures. The most notable document that we have that has come up with regards to the wet signature requirement is the note itself. There's other documents in there like, perhaps a mortgage on the buyer side that they wanted to be wet signed, but the lender is going to dictate a lot of times how and which documents need to be wet signed. And that would then go outside of the realm of this e-closing kind of capability and this RON, because obviously at that point we need to make other arrangements to make that wet signature possible. The e-closing too is, it's difficult because under the rules from the lender, and we'll talk a lot about the 4 pillars here in a minute, the 4 parties that are subject, but a lot of the requirements is that they use one of the vendors that are approved by the lending industry and by the title underwriters. And so you can't just get on a Zoom call right now and e-close in the same way with a notary without a notary on site, right? You can't just get on it, and you need somebody present to exercise and do all those things. So that's e-closing. You hear a lot about e-closing. Now, what are we talking about when we talk about RON? Well, RON is, of that closing package, some of those documents need to be notarized. And if we don't have a notary on site, or if they're not able to get to, they're in quarantine and they're not able to get to a notary at a bank, there's difficulties going on getting scheduling. What are we talking about? Well, remote online notary has existed in other states for some time now. Virginia notably has a statute that recognizes remote online notaries. And what it is you sign on to this platform. There's 5 vendors in the country that have the capability to host a RON closing. And so all the parties, the signer, the title agent, and the remote notary would log into the vendor platform. It's secure. You go through the documents, they're uploaded for e-signature and remote notary, and a notary actually signs on with you, much like we're doing right now, and will verify using their technology. They hold their ID up to the screen. Their software will verify that in fact is the person. And then there's other requirements with regards to that the person has to be a United States citizen, and that software will verify that both parties have already consented, and the notary's there, that the lenders consented, that it's being audio and visually recorded, okay, and have to be kept either by the vendor or by the title agent. And in Delaware specifically, there's a requirement that for title insurance to be issued, it has to be less than $1 million transaction. Let your attorney worry about that. But they'll get approval if it's more than $1 million, but there has to be approval in advance. So there's different requirements for the state. And obviously the RON platform is where we host and sign the documents. And what happens is that the notary actually gets on and digitally stamps the document with a digital notarization, stamp, for lack of a better word, sorry. And the question is we're using the notary in a state that currently has the ability to host that. So Virginia, Florida has the notary, I believe Texas does. So we're actually logging on and using notaries in those states, and then filing the documents, either whether it be in Maryland or Delaware, with a notarized document that's valid in another state. Now, the full faith and credit clause of the Constitution says that any document that's properly executed in any state needs to be given full faith and credit and hold its weight with regards to in the state that it's being filed, i.e. if something is notarized in Virginia, it has to be given the full faith and credit in Delaware or in Maryland. The governors have come out specifically, Governor Hogan and Governor Carney have issued modifications to their emergency orders allowing and directing the offices to accept RON documents. Now, there's the law of the land, and then there's clerk law. And we'll talk a little bit more about that when we get into the pillars, but there's bumps in the road when it comes to actually getting these recording offices to give them acceptance. But that's just one of the hurdles. But basically what you do is you log onto these platforms, and there's 5 vendors in the whole country that do it. Notarize, NotaryCam, Nexus, Pavaso, and Docs Verify. They're the only 5 companies in the whole country that do RON closings. And so the waiting list is extensive right now for title agencies and the attorney's offices to get signed up. Luckily, my company and a few others in the area are already signed up. And if you're interested in a RON platform, we're going to go over that more. But I would make sure that when you're looking at RON, that company is using that vendor. Otherwise, they're not doing it correctly. So now we're going to get into really the 4 pillars of what a RON and how RON kind of works and what's going on with that. So the 4 pillars are, there's 4 people that really drive the closing process, and that's the government, title insurance underwriters, lenders, and then title agents or attorneys. So in the last 3-4 weeks, we've gotten all these people to come together and really work together to try to get this thing on the path to viability. And there's still some bumps in the road. And that's my purpose of this whole proceeding, is to identify that and let you know that, yes, companies are going to be touting these RON capabilities, including my own company, who's going to tell you that we can do this thing. But there's other players on the team, and they all have to be working together, or the system won't operate, and you will not be able to, your clients may not be able to do a remote online closing. And the first pillar of this situation is government. And obviously we're subject to the government's orders, these states of emergencies. And the governors have come out and stated that electronically notarized documents have to be in compliance with regulations, and they have to be established by the vendors in order for it to be valid. All parties have to consent. The situation has to be recorded, and the notary has to be valid in the state where they're executing the documents, i.e. Virginia, Texas, Delaware. Maryland is moving that way to allow for remote notaries to register. We're in the process of getting that done. The Secretary of State is moving quickly, but they're not there yet. They're in the process of registering. Once that happens, it will make it so that phase 2 of this implementation, I'm not going to talk about that, for our company would be self-driven, meaning we wouldn't have to wait for a separate notary. We as title agents in Maryland could notarize our own documents on the title vendor platform. But that's not ready yet, so we have to kind of go with the outside notaries. Delaware has said it's okay. Maryland has said it's okay. However, clerk law is what the major hurdle is right now. Maryland has issued, the Secretary of State's issued direction that all clerks' offices and recorded offices have to accept RON documents from any, if they're properly executed, from any and all states that are valid that can do so. Delaware has said that. However, when verifying it, we've only gotten a firm yes from the recorder's office in Sussex County. Surprise, surprise, it's slow trickling down to the recording offices. So Sussex County's given us a firm yes, we will accept RON documents. Kent County has said, maybe, we're not sure yet. And Newcastle County's given us a straight no. So we're in the process of working with the Attorney General, with the Bar Association, with the local Bar Association, and getting a one-track direction from government with regards to this. And obviously during these times it can be difficult to do that. So those just one of the pillars and one of the hurdles that I point out to you is if you have a deal in Dover, or you have a deal up in Newcastle, or you have a deal, even in Maryland, and you get a recorder of deeds where they don't accept a deed that's stamped digitally, there could run into a problem. And so we're trying to get clear-cut direction from the government, which can be difficult at times. Second pillar, obviously, is the title insurance underwriters, and they drive a lot of what we as title agents and attorneys do, because we issue policies which protect our clients, in Delaware especially, from subjecting them to defects in title, and if there are defects in title, they're covered. The title insurance underwriters have come out and said, yes, we will allow RON closings. Initially, when they said it, all the title agencies came out. All of them have the different requirements, as I stated, with regards to amount that we're talking about, amount of sale. It has to be less than $1 million in Delaware without approval, U.S. citizenship, that everybody consents, that it's recorded, all the things that I've already talked about, but they have said that they're valid. There is an issue with some of the, now, 2 weeks later, we're getting direction from some of the title underwriters, specifically the ones that I work with, that have come out and said, oh yeah, we'll accept the RON settlement, but in the title policy that we're going to give to the lender and we're going to give to the client on an owner's policy, we want an exception carved out for any defects in title as a result of that digital notarization process. Meaning if there was a defect in a deed that was digitally notarized, it's not covered under the title policy. Well, that's contrary to why we're doing this. So we've gone back to them and said, WTH, this is the whole reason we're doing this. Now you're frustrating the purpose of this whole thing, and we have to go back to the drawing board and get it cleared. So that's another one of the hurdles that we're dealing with within the RON world, is obviously getting approval from the underwriter to implement a policy which protects defects as a result of this electronic process. Again, as an underwriter exception, or as an underwriter requirement, it has to be completed. All underwriters internationally or nationally are saying that it has to be completed by one of the 5 vendors. The third pillar, and very important are lenders. Obviously, they drive a big portion of what we all do every day, and they have been, quite frankly, the largest hurdle that we've had to encounter. And it's not a negative thing. It just means that this is new to everybody. This process is brand spanking new. And so everyone is getting comfortable with allowing this type of proceeding to take place. But the biggest hurdle with the lenders is getting the lender to accept e-signed documents. A lot of them tout that they have e-signed capabilities, but they don't necessarily have full e-signed capabilities, or their investors are saying, yeah, we say that, but we really don't want them to e-sign, and we're not allowing it on this particular purchase. And so getting them to accept and give instructions on how they accept RON settlements is a big thing. The other thing that we talked about was getting wet signatures. As I indicated before, their documents, i.e. the note and other required documents that most lenders require to be wet signed. There is a program within lender platforms, and they register for it if they're doing e-closings, called e-notes or e-packages. And what that does is it allows for the note to be kept and e-signed. However, only 25 companies nationwide have the capability for e-notes. And so a lot of them have to incorporate wet signatures, which throws a little bit of a curveball when we're talking about an RON settlement, because that's just one more document that we need to get wet signed and have to do something different than within the capabilities of getting on Notarize and having that document implemented. The other thing is whether or not they're integrated, meaning that their software settlements and their documents have the ability to be uploaded onto the platform for e-signature. That's alleviated, at least with Notarize and a few other companies, because the attorneys and the title agents who have it have the ability to transform the package from something in paper form to allowing for an e-signed document. So we have to make sure that they're integrated. And then if they're not integrated, make sure that we get their documents in advance and turn them into e-signed documents if we're allowed to. One of the other things that fixes wet signature requirements is what we're calling hybrid closings. So there's the opportunity for all the documents in a package to be e-signed that are capable of being e-signed, and then doing a quote unquote mail away where we email the note and the documents that need to be wet signed for signature to the party, complete it with them. They actually hard sign it and then mail it back, much like a straight mail away, as we would call them in the industry. And hoping that alleviates the lender's concern. Obviously, there's a mailing portion that would delay getting the documents back to the lender, so we have to get permission from them in advance to get that accomplished. So as you can see, there's limitations with regards to the lender in specifically getting their investors to accept it. Fannie and Freddie have come out and said RON settlements and the documents in e-closing, we're fine backing those loans. So we have, feel good in my industry that Fannie and Freddie the big uns came out and said, we're going to back this with our support. And so that gives a lot of, incentive for some of the other backers to go ahead and say, yes, we can do this. The other thing is that some lenders have straight said that if there's not a state statute on file, and there's not in Maryland or Delaware yet, it's just governor's orders, meaning the legislature hasn't come out and said this is okay, and they're the ones who pass laws. Governors don't pass laws, as we know from high school civics. So there's no statute on file, and if there's no statute on file, it's concerning, and they're not going to allow it because there's no statute on file in Delaware and Maryland. Some of them have said that, and some of them just straight are not integrated with those platforms, and they say, well, we don't have the capability of doing it. Well, we can help that situation if you let us, but if they're going to dig their heels in, then there's nothing really we can do about it. So those are some of the biggest hurdles that we run into from a lender perspective, and that's not poo-pooing their industry. They're getting there. Right now, there's a lot of, I've talked to a lot of them. My boss talked to a lot of them. Their biggest thing on their mind right now is liquidity. They're dealing with that and getting that taken care of. And then once that's kind of settled and they have money to give people, they'll start moving towards addressing some of these issues that we're having with RON. So we're getting there. We're getting there with them, and it's happening quickly. Maybe not as quickly as we all might hope, but it's getting there. And then the last pillar is the attorney's offices and the title agents. So how are they complying with their underwriters? How are they reaching out to their government to make sure that these documents are acceptable and able to be recorded? And then are they dealing and working with their lenders to make sure that they can integrate, that they can hybrid, that they can wet sign mail away? How are they working? And what vendor are they signed up with? Obviously, as I spoke to, there's only 5 in the whole country, and they kind of taken the approach that if you weren't with us before this whole thing happened, we're not really going to let you on board now. You're going to have to wait until we kind of service our existing clients. So the waiting list is quite robust for getting involved with these vendors. And obviously, going into a notarized platform, it's unique because we're in a video chat much like this, but if we got trained on this about a week ago on how it works. And how it works is basically the party that is in notarized, at least the party who's signing, the attorney or title agent, and the notary are all accessible on this session, as we'll call it, audio and then visually. And then the ability exists for agents and lenders to call in and be on a telephone call through the online platform. And that's great because that allows you to be part of the process if you so choose to be. It allows lenders to be on the process if there's a problem. And obviously we as attorneys and title agents are cognizant of the fact that we want you all to be integral parts of the closing as much as you want to be and as much as you feel like you need to be, because that formulates relationships and it helps in those what we call stressful times. They have a relationship with you, so it's nice that you're a part of the process, especially when they're embarking on this kind of what is seemingly maybe a scary situation for them, and obviously it makes it even more scary when they're doing it electronically. So there is audio and video participation. We're pushing Notarize, and they're working on getting more video capabilities within individual sessions so that perhaps you could be on a video conference with them. That's not quite there yet, but they're working that way. The only issue from Notarize's platform that we've run into is, quite frankly, that they have a finite number of notaries. And so when we're doing a lot of these RON settlements, there are wait times established when we log on to request a notary. And it's like when you call an Uber is the best analogy that I've gotten, is we get on, we do it, and when we're ready for the notary, we call the Uber driver and he comes and logs on and notarizes the documents when he's available to do so. And I've heard that there's not extensive wait times, but like up to an hour. And so what we've come up with in my company is like, look, we're just going to log on, we'll drive, and we'll immediately request the notary as soon as we log in with the parties. We'll go do all the documents that we can do prior to and save the notary documents for last. And then hopefully by that point, we won't have a long wait time, or hopefully he'll be on by that point. So that is one of the other little bugaboos. And obviously that will be alleviated when quote unquote phase 2 comes along, when Maryland allows notaries, at least for my company, because even on a Delaware settlement, then I could use one of my Maryland notaries digitally on the platform and not have to worry necessarily about using somebody outside of the ability to do so. But Delaware currently has no electronic notary capability, meaning there will be no notaries who have the ability to digitally notarize documents in Delaware, at least for right now and into the future. In fact, I'll go over some of the Delaware differences here at the end but Maryland does have the capability. They're working towards getting everyone registered so that we can implement that. We're hoping by Memorial Day that we can start handling settlements and self-driving the process and not have to rely on another notary. So that's really RON in a nutshell. And it's really new and it's really exciting from our standpoint, because the technology now exists for us to do virtual settlements. And one of the things that I'm seeing is that that I think, just as my own thoughts on this, is in the short term, we're going to be able to overcome some of the hurdles in the next couple of weeks with quarantine buyers, out of state people that can't come into Delaware under the governor's rules, or at least are limited once they get here. And then I think really long term, what we're looking at is this is going to be a really sophisticated tool for seller signings. on out-of-town second homes, on refis where we don't have to do a walkthrough. We have some sophisticated buyers from an investment property standpoint. So they're looking at Bayville Shores where we live. We have a lot of good idea of what the unit's like. Don't necessarily need to walk through everyone. We've seen them. If one comes on the market, we can, sophisticated buyers would be willing to not just let you walk through and get under contract, but do a digital e-closing. And then younger, obviously professional people who are comfortable with the technological aspects of this, the Generation Z is probably going to be more inclined to handle this. I don't think a lot of the older clientele who are used to sitting down at the table with the attorney are going to be really comfortable, at least early on. So really long term, I don't see this as the new norm necessarily. Maybe in the long term, and as my boss likes to say, though, once we implement this thing and get it working, and it's on its path now, if not there, in a lot of ways, we really can't put the cat back in the bag as far as not allowing this to go forward. So a lot of the government and a lot of the bar associations are pushing for this to be not just a short-term fix during this crisis, but long-term, using this and implementing it if it works, and using it as a useful tool for agents and attorneys to use. And obviously lenders will like it too because of the ease of uploading and onloading documents back and forth. And obviously they don't have to worry about getting things wet signed all the time. So some of the things that are different in Delaware, obviously, Maryland is moving towards it faster than Delaware, surprise, surprise. Delaware is just a little bit slower to implement these things. And some of the things that Delaware has done to alleviate it, as I stated, they don't have electronic notaries. However, last night, the governor at 8 o'clock last night signed a modification to the notarization statute. So it used to be, if you were a notary in Delaware, you could only notarize a document if that person was in your physical presence, okay? Standard boilerplate notary stuff. What the governor's done is, if you're an attorney and you're involved in a real estate purchase, or anything really that requires a notarization, but only attorneys can do this. They can log on to a Zoom session, much like we're on right now, verify their ID using 2 forms of identification. Why 2? I don't know. As long as the signers are in physically the state of Delaware, and they have to certify on the call or on the video session that they're physically in Delaware. How we check it, I don't know, but they're swearing that they are. And then we can have them actually wet sign the document in their presence, mail it to us, and we are able to notarize it after the fact. So we no longer need the physical presence of a notary in Delaware. So Delaware's kind of circumvented this RON requirement for people who are in Delaware to allow for virtual notaries. Now, what's the difference between a virtual notary or virtual settlements and a RON and an e-closing? Well, they're all kind of sound similar. Obviously, I've outlined what an e-closing is from a lender standpoint, from a settlement standpoint. I've outlined what RON is. Virtual settlements are kind of encompassing both of those things. And a lot of people are doing virtual settlements. I do virtual settlements now. And the way I do it is I sit in my office and I video conference into the conference room. And I'm in the vicinity of those folks who are signing so that they can sign and then I can notarize the documents. I've heard of drive-through settlements happening whereby, and I would consider this virtual, whereby the buyer pulls up in their vehicle, we slide the papers through the window, they go through them, we go back into our office inside and FaceTime or call them and go through it. They sign them, they then slide back and we notarize the documents. That's within the vicinity requirements as well. I've heard attorneys are getting creative as long as they're meeting the statutory requirements. They technically are handling virtual settlements. So you're going to hear a lot of marketing about virtual settlements. We can do this, we can do that. I would encourage you as the agent that you drive the situation, and your clients are the ones who they trust the most. So if your clients are apprehensive about it, be sure to call the attorney's office and say, how are you going to handle this settlement? How are you going to virtually do this? How are you planning to get it accomplished? And then have them talk to the client, or you talk to the client, and make sure that they're comfortable doing it that way. It's important that everybody's on the same page with this because, you know, we're already in what I would deem a stressful situation of buying a home anyway, buying and selling homes. Add the pressure of an electronic situation and a quarantine and a pandemic, and people get really panicky. So the more communication that you can have with the attorney who's hosting this thing, and the more transparent they are about what they're actually planning to do. You know, I had a call with an agent yesterday, and she said, well, I have out-of-state buyers and sellers. How would you do this? And I said, well, there's a lot of ways that we can do it currently. RON being one of them, if we can get everyone on the same page, and all the vendors and lenders are on the same page, and we can get title insurance issued appropriately. But there's other ways to get it accomplished as well. So this is just one of the ways that people can do it. You're going to hear a lot of people touting this RON ability, us being one of them. I'm sure maybe some of you got an email mass sent the other day that we're 100% E, and we are, but there's other players, as everybody knows, in this thing. And so I don't want to make anyone feel like we're the only ones in town that can do it, or make anyone feel like, you know, how dare people not be able to do it. It's advanced stuff. And so I'm not here to tout our abilities versus anybody else's abilities. I'm simply here to clarify and help you guys understand what the difference is between an e-closing, a virtual settlement, and a RON settlement, and understand that there are hurdles with everything in this market right now. And obviously, you know, what issues are you all, you know, concerned with? You know, just off the top of my head, and I'll take questions obviously at the end of this. Either you guys can ask me directly, or you can type on the chat. But, you know, concerns would be attendance. How can I attend? How can I be involved? Obviously, depending on the vendor's platform, as I stated before, you can be on calls. How am I going to get a check? You know, how am I going to deposit EMD checks in Maryland? Again, remotely, if your office isn't open or you don't have somebody on site, you know, there's ways that my office handles it. We have in Maryland, we have an app called Zacom, where you just take a picture of it and then it electronically uploads, and then we get the parties to sign the escrow disclosures, of course, and then checks. You know, we can even wire you money. And I know Betty may have a fit with this, but if the situation is dire enough and you want us to just wire you the money, we have the capability of doing that. And then how do you drive your relationships virtually? How do you make sure that this is a positive process? Because obviously the settlement is the last piece of the puzzle for what you're selling to these people, and you want them to come away having a positive experience. And if this isn't going to work, or there's going to be hiccups, obviously that's something that you guys are going to be concerned with, and we understand that, so we want to make it work too. Obviously, I've heard questions about walkthroughs and liabilities, and the last thing I'll say with this is that with this whole situation, virtual settlements and everything, no matter whether they're doing it virtually and people are coming to the office and video chatting, or they're doing a RON, or they're doing an e-closing, they're no longer in these platforms going to be joint closings. Buyers and sellers are no longer going to sit at the table together. You are no longer going to sit in a room with 6 people in this world that we live in now. It may be that we go back to this as we get a vaccine or whatever, but there's not going to be joint closings anymore. You're going to have multiple sessions. And the question I had asked is, if there's multiple signers and they're both sellers, they can be on the same session with the notary. However, if they're sellers or buyers and they're in separate locales, meaning we have 2 buyers, one's in Alaska, one's in California, they have to have separate sessions. Buyers and sellers have to have separate sessions on the notary. So that delays things as well. Obviously, you have to consider costs because obviously that vendor is charging the client for that time, and we would pass that through as part of the settlement, obviously. So that's a consideration with cost. Normally, I'm being told, and again, this is very new and we're trying to negotiate it, and I would say that as the more we get, the less the cost will come down. However, right now, per session, they're saying, I think it's around $110 a session, which whoever party is requesting it would be passed through to them. So the most important thing that I want you all to walk away from this from today is just making sure that you understand the different requirements and the different situations with regards to understanding what an e-closing is. You know, it's an electronic platform with digital signatures, mainly from the lender side, where they can digitally sign documents. Now, whether that's accepted or not is up to the lender and up to the title company, quite frankly, and up to the title insurer, because they may have their say as well. And then making sure that you understand what a RON is, because you're going to be hearing a lot. It's a very popular. It's like, I don't even know, it's like Merlot back in the day when Merlot got famous. It's like very hip right now to be RON compliant. But you're going to hear a lot about our abilities to tout RON and what it is. So understanding that what RON is and what the requirements are. Some people are going to tout RON and they're going to say we can do a RON closing, and they might not be able to do it, or they might not be doing it properly. So the more you understand of what it is, the more you can help drive the conversation and drive the fact that we are in compliance and getting this thing done, so that there's no hiccups or no problems down the road for everybody. And just understanding what it is can help you explain to your clients and give them a level of comfort that, hey, this attorney, you know, Chris is going to call you and he's going to say, you know, we have this capability. Are you comfortable with that, or should we talk about something else? And that's really what my goal is of today, is to help you understand what it is, and understand, you know, the difference between the platforms and what it is. So that's really all I had to present to you guys. Obviously, it's an ever-changing field, and it's an ever-changing you know, platform and vast landscape that we're kind of venturing into in 2020 as a result of this. But I would, if anyone has any questions, Bridget and Walt and a few other of you have my contact information, be happy to email or call. We could do Zoom sessions. I always love to do Zoom sessions in the morning. It's nice to have coffee with somebody who isn't my son, who doesn't talk back. But yeah, I mean, if you guys have any questions, I would encourage you to either speak up here or just type them into the chat now, and I can answer them as I come. It might be easier to just do chat given the volume of people that we have, but if somebody feels bold enough to chime up, please do. Thanks, Bridget, Walt, Becky, everyone who is involved in getting me on this. I appreciate this opportunity, and if again, if you have any questions, feel free to reach out. Thank you so much, and yeah, I'll take questions.
Thank you so much, Chris. I really appreciate your time, and that was really informative. We've definitely been hearing all those terms, and to be able to hear the definitions and the uses and what some of the hurdles have been and are really, really helpful. So thank you. You did an excellent job explaining it all and really breaking it down. And it was really, really easy to understand. Walt had a question on.
Yeah, I see. Walt, is there any limit for VA or FHA loans? Not that I know of, Walt. It really is lender driven if they can do it. We haven't heard any hiccups with regards to typical types of loans, other than I've heard FHA loans are becoming impossible to get right now under the new liquidity situation that we're in. Not impossible, but next to impossible. But I haven't heard any limits for any types of loans as far as their limits for RON capability or e-sign capability. Other than the loan application on a VA loan where they're certifying that they in fact are a veteran, I would anticipate that probably has to be wet signed. Yeah. I knew we were going to get a question about walkthrough liability. I knew it, Emily. Love you. I've gotten so much. Walt, you want to chime in first and give your Keller Williams company line?
We are not liable. You know, a walkthrough, virtual walkthrough, you know, we just have to make sure that people understand it. You know, they cannot hold us responsible. Our contract states that. It indemnifies us. You know, they won't be able to smell the mold or you know, or smell the carpet or any of that. You know, you just got to do the best you can possibly do when you do a virtual walkthrough, and you have to ask them specifically, do you have any questions? And if you notice anything, You know, you have to say, well, it smells like they smoked, smells like they did this, you know, you know, the more upfront you can be about it, the better. Is there something we can sign? I honestly feel the contract already covers that. You know,
Yeah, I mean, I know. Yeah, I agree with Walt. The contract does address it. If you guys wanted to, you know, formulate an addendum just to have for your agents that said in this situation, in this environment, that says, look, you know, we understand you're doing a virtual walkthrough. We agree to hold you and your agent harmless for any damages or claims resulting as a result of this, you know, of this process. That might not hurt. Emily, if it were me, just if I'm not giving necessarily legal advice, but just covering my business practice advice would be, I might just email them and say, look, here's my concerns, that I don't want to be held liable for this situation. You know, can I get something written in email form that says you're not going to hold me liable if there's a, you know, defect? I think your contract would cover negligence on your part, meaning simple negligence, meaning there's a crack in the wall. You're not an inspector and you're not a construction expert. You wouldn't know what that necessarily means. And if you didn't point it out and it was something that you deemed minor, that might be covered. If it's a gross negligence situation, meaning there's a leak in the roof, there's a hole in the floor, there's a, you know, a significant crack, or there's some sort of latent defect in the property, I think that you might still be liable for those situations if it was a gross negligence situation, meaning a normal person is going to walk in and see a blatant defect. And if it's noticeable, obviously they're going to have a claim not just against the seller, but potentially against you for your gross negligence if it was something that was readily identifiable, in my humble opinion. But the attorney in me is screaming, get something signed to cover your base, but it doesn't have to be fancy necessarily. Just making sure that they understand the risks associated with this and that they are waiving the potential of going after you. That's what I would say.
We do have an addendum now that addresses people buying properties sight unseen. It is in dot loop. I suggest any agents on this call, you go to dot loop and review that document ahead of time. And if you need to adjust it for a virtual walkthrough, you know, feel free to reach out to me with any language that you would like to use, or if you need suggested language. The language is always going to be, you hold us harmless and indemnify us for any damages or known or unknown defects that arise from a virtual walkthrough. I mean, that pretty much would cover you, right, Chris? I mean,
Yeah.
But our contract already states that. Our contract already states that the agents are held harmless. We're not responsible for the condition of the property. We're strictly the messenger, and in this case, we're a virtual messenger. You know, again, like Chris said, if the roof was falling and you didn't point it out, and it wasn't that way when they placed the contract, you know, that would be an obvious latent defect or something you hid. That would be what's considered gross negligent, meaning you either did it on purpose or you were just, there's really no excuse for you not to bring that to their attention. But for the most part, our contract does cover us. And I think the courts would look at that as well as, hey, here's a contract, here's what we do, here are the situations we are in at this time. So, but again, anything that, as long as it doesn't negate what's already in the contract, and that's where we have to be careful, is not to write an addendum that creates liability.
Correct.
Already have a blanket indemnification to begin with.
Correct. The only thing I'd be careful of is, and piggybacking off Walt's statement, is just don't create a duty on your behalf. So don't by your actions, don't do more than you feel is being asked of you. Don't create, you're just the messenger, like Walt said. You're not the owner, you're not that party. You're doing them a favor, and and keep that in mind. Don't take on anything in excess would be my, because if you create a duty on yourself, then of course going to say, well, yeah, you were covered, but then you went back and created a situation where you took on more liability and now you're not covered because you took on more. So like Walt said, don't rewrite the contract and don't take on more than you necessarily are obligated to do per se.
Okay. Any other questions?
Chris, right now, if someone goes to your office and they meet someone in person, how does that work right now? Do they actually sit at a table with a person or what?
Every office is different. Every office is different. My office, the way we're doing it is they go in, the documents are on the table. They don't have any personal contact with anybody other than a paralegal who is basically pointing them to a room, to our conference room, and she's seated behind a desk, which is 10 feet away from where they're going to be working. And then the documents are already laid out on the table for them to sign in my office. And then I'm just on a video chat in the other room, and they sign, and I'm in the vicinity. And then either Corinne or myself, who's in the vicinity, will notarize those documents that they signed. And the way we're doing it is that when they come in, we have a box on the on our front counter where they leave their IDs. And obviously we take them, Corinne uses gloves and we wear masks. And then and the conference room is cleaned head to toe prior to and after every settlement with Lysol spray. So the signers, whoever's signing those documents, are the only people in the room. That's how it's working, at least in my office. I know people are doing car settlements, meaning they're making people stay in their car. We have implemented that on one occasion where the person was sick. So if they are sick, we have disclosures telling them that they have to tell us, and then they have to stay in their car. And then we have extreme measures that we go to make sure that we're not interacting with that person or the papers on any more than we have to, and we're exercising extreme caution. So every office is different. So if you have a settlement, I would encourage you to contact them and say, what implementations, what procedures are you guys implementing? How are you going to do this? And or have your clients do it for that. But yes, they come in, they sit in my office right now. And obviously we've done, that may change with the new RON, with the new ability for me to, excuse me, notarize documents for people sitting in Delaware. That may change just the way we do it, but for right now, that's how we're handling settlements and refis.
Suppose someone said to you, I tested positive for COVID-19. How would that change the process?
Yeah, it would change it tremendously. We would really tell them one of two things. To limit exposure for my own staff, I would say, what ability do they have to meet another notary, close in time? Because if they have COVID, they're probably quarantined for 14 days. So if they have COVID and they're actively symptomatic, I would probably get with the agents to say, we need to postpone settlement for at least 14 days so that we can get this person at least through the symptomatic portion of it. And then we would exercise extreme caution in having them either come and do the car signing, like I said, where we have a drop box in my office, so we don't even have to slide things through the window. We just leave it in the box. Before they get there, we walk inside, they come in, they grab the docs, and then they go. So we really try to limit contact with COVID patients. If it was a COVID situation, we're probably going to postpone it. I understand that people have deadlines and other deals going on, but in that situation, I think it's a public safety hazard to have anybody sign with symptoms. And I wouldn't want to bring anybody out in that situation either, out of their house.
Could they do it through the RON?
Yes, if their lender is capable and can get the documents uploaded, and we have yes, we could do it. Yes, the answer is yes, we could. My company could, if the lender gave us permission and we were able to integrate, we could do it on a RON settlement.
If that were the case and there was a seller, do you think it would be our obligation to notify the buyer that they had tested positive?
If you represent the seller, I think yes, it would be. I don't know if it would be the agent's liability to notify, but I think someone needs to notify the clients, just because the potential for postponing or continuing settlement exists, and they have a good reason for it under the new addendum, as well as the fact that I know if I were buying a house and the sellers were signing docs, and I just would want to know. But I don't know legally, other than the fact that it might get postponed or measures might have to be taken above and beyond to get it done, whether or not there would be any liability per se. I don't know that to be the case, but I don't know if I answered your question or not.
Well, it's really, I think you did, but what I was getting at is that, gosh, is there an obligation for us first to ask our buyers or sellers if they have it? And since it is contagious and could actually harm someone, then is our obligation to notify the other party. For example, if a seller had it and they were signed and they had lived in that house, do we need to notify the buyer that, hey, we're hearing all these stories about cardboard and plastic, and who knows about linoleum being contagious for a time afterwards. And I know this is probably, I'm not trying to put you on the spot, but just, without being an attorney, as far as the attorney-client privilege here, this is strictly just, in your opinion, what do you think someone should do?
My opinion would be that that if your only probably liability exists if you know about it. And so it's similar to the virtual walkthrough situation. If you are asking, you only need to protect yourself per se. But if in my opinion, if it's a seller situation, they lived in the home and the buyer's going to be moving in, to me, that has to be on the seller's disclosure. I mean, that is a hazard that exists in the home that needs to be addressed by the seller, in my opinion. And I think that's not a material latent defect, but I do think it's a hazard that exists on the property. Whether a court's going to agree with me or not, I don't know. But if it were my sellers and I were selling the property, I would tell them to disclose to the buyers that they had COVID and that they exhibited symptoms in the house and they quarantined there, just for my own purposes. Now, you as the agent, your only responsibility exists if you know something. So if the sellers comes to you and you don't know that they had COVID prior, then I would say that you don't have any liability to tell anybody. And I'm not sure even if you knew you had liability, but if I knew and my client told me that the roof was falling in, that's a material latent defect that I have to disclose under the rules, under the ethical rules. I think this is similar and runs of a similar line to that than anything. So I always err on the side of disclosure. The more information that you can share ethically and legally with all parties, do it, especially with something as contagious as this. You don't want to be like in a situation where the seller has COVID and, not that it's like a lot that you're going to be liable if you give it to anybody per se. I mean, it's such a contagious disease. I don't think individuals can be liable, but I don't know, it's a moral compass thing, maybe. I don't know. I think you can disclose it if you know about it. I don't think it's something that would be covered under the ethics, excuse me.
Yeah, well, and see, that's going to be the other side of the curve when, 6-8 weeks from now, when we start dealing with people that have been exposed or have had the disease and recovered. And I think we're all still in that questionable stage of how long, and for, really, that's it. How long? how long after someone has it that they're no longer a threat?
And they don't know that. So,
struggling.
and they don't know that for sure yet. And so I think that's a question that I would say, you know, your leaders, yourself, Bridget, you know, Matt, and all the people need to get with DAR and get some direction on how realtors are going to be handling that from
Thank you.
mass. Yeah, that would be, I would get DAR's standpoint, but I do think if it were me, and I'm the agent, I'm disclosing.
And we've had that once, and Bridget was working on it with Andy Taylor, and I don't know if we have a definitive answer or not.
Yeah, his recommendation in that particular instance was he recommended the virtual showing, and to, but he didn't say that that individual should sign the document, because obviously in that situation, the way that document was worded, he couldn't sign it. But he certainly recommended the virtual showing, and he also suggested that we notify the seller and make sure that the seller consented to having him view the property.
Got it. Yeah, I mean, I think it's just the more information you share, the better. Just my 2 cents.
Yeah.
But
Well,
within the rules of ethics, obviously.
yeah. Well, it's interesting you kind of bring up about just getting feedback to DAR and working with DAR. They literally just sent out an email update on unemployment for independent contractors, as well as they included a survey and asking all Delaware realtors to complete the survey, looking for feedback as to what would people recommend, suggest in as far as maybe best practices, protocols, processes for kind of reopening, if you will. So, you know, what you were just talking about would certainly be things that people ought to be putting in there and asking, and as far as getting just that type of guidance would be helpful.
Yeah, I mean, I definitely think DAR is going to be driving, and they have legal, you know, on staff that is going to work with the governor and work with people. And the more that everyone can be on the same page and how to attack it, the better. So Cindy looks like. That's a good question from Cindy. Have you had, or should we be asking, have you had, or do you have COVID? Should be asking every customer, buyer's agent, buyers, sellers. I mean, if you're coming in contact with them, maybe I would.
Yeah, if it's a face-to-face meeting for your own self-protection, you should absolutely ask that question. If it's virtual, it may not be an issue.
Yeah.
Well, and that showing certification form, that's essentially what that showing certification form asks for, which we've made available in, you know, for all of our agents to be able to access and utilize that. So that's how that situation came up, it was presented to the buyer. And that's how we found out, right? Because he then disclosed it. I can't sign this form. He himself didn't have it, yet he had been in contact with somebody that had. And so that's how it all came about, was because we presented that form to him.
Mm-hmm. He says, if you ask one person, don't you have to ask everyone?
It depends on whether they're coughing or not. No, I mean, you know, you have to use common sense, right? You have to use common sense. And if you're going to meet with someone and you're high risk, or, you know, suppose you're an agent and you've been exposed to it, wouldn't it be your obligation to tell people? And you would expect the same respect if someone was going to meet with you and they had it. Can you ask that question? Yes, because it can directly affect you and your well-being, right? So, you know, and we're going to ask for guidance on that. And I'm sure we're going to get some from Maryland Realtors as well as DAR. And that's kind of, again, that's the other side of the curve that we're going to be dealing with as hopefully we get back to business in the near future, but these are questions that we're definitely going to have to ask. And I think us being on the forefront only prepares our agents and us to ask those questions and know what and how we should do it. And Chris, I appreciate your time. I know we've been on the phone an hour. I don't want to keep people too much longer than that, but you know, you're a good son-in-law, and I appreciate you calling.
Thanks. Thanks. I'm going to go upstairs and check on your grandson. If anybody has any questions or concerns, you know, my contact information's available. You can email me, call me, Walt, Bridget. Most of you know how to get in touch with me. Again, I'm happy to share information. If any of you have deals that are upcoming that you need some help with, and you have questions about what an attorney has said to you and you're confused, or a paralegal has said, I'm happy to, you know, I don't want to step on any toes, but I'm happy to try to help in any way that I can. And I wish everybody the best of luck throughout all of this. Again, hang in there. I know better times are ahead of us for real estate. I just, if I can help it.
What is your cell? I'll put it in the chat, and I'll put it in.
443-783-0286.
Okay. And email?
And then my email address is chris.mancini at Ridgeway without an E, so RIDGWAY, LG.com, all groups.
Great. Super. All right. Well, I just put that in the chat. So thank you.
Yeah.
Thank you.
Thank you all.
I really appreciate it. Hugs to that baby. Hugs to your wife. Thank you again. Appreciate you.
Have a wonderful rest of the day, everyone. Good luck. Take care.
Thanks.